in our hearings, and then I would have an opportunity to, we would have an opportunity to hear those. I want to inform committee and those interested that we do plan on working a bill that we heard last session. We do plan to work that next Thursday, so a week from today. And the bill number is, want to make sure. So we'll be working House Bill 2378, establishing the Removal of Squatters Act, providing a procedure to remove a squatter from a dwelling unit, requiring owners or agents of dwelling units to provide an affidavit to the county sheriff, requiring notice to vacate by the sheriff, establishing the crime of providing a false affidavit, and establishing a civil cause of action for wrongful removal of a person from a dwelling unit, attorney fees, and punitive damages. So the reason I'm announcing this is we did hear it last year, so make sure you have refreshed yourself on it, and most importantly, if you have any amendments, make sure that you have those ready for committee as well. So with that then, we will open the hearing on House Bill 2479, authorizing electronic monitoring with victim notification as a condition of release prior to trial for certain offenders charged with a domestic violence offense, domestic battery, stalking, or violation of a protective order. And with that, a bill brief from the reviser.
Thank you, Madam Chair. Section 1 of this bill would propose a new section of law under the Code of Criminal Procedure. If a magistrate is required to consider ordering electronic monitoring with victim notification pursuant to KSA 222802, then the magistrate may order that electronic monitoring pursuant to this section as a condition of release. Nothing in this section would be construed to limit the magistrate's authority to order electronic monitoring in any other situation without victim notification under 222802. Section 2 amends KSA 222802, which is the section related to release of people prior to trial. The bill adds a subsection that requires the magistrate to consider ordering electronic monitoring with victim notification as a conditional release measure if the person is charged with a domestic violence offense as defined in KSA 215111, domestic battery, aggravated domestic battery, stalking, or violation of a protective order. As used in that section, electronic monitoring with victim notification would be an electronic monitoring system that has the capability to track and monitor the movement of a person and immediately transmit the monitored person's location to the protected person and to local law enforcement. It could be by any means, including but not limited to the telephone, an electronic beeper, or paging device, whenever that monitored person enters near the protected premises. Protected premises would be a location that the magistrate has ordered the monitored person to refrain from entering or being in. Section 1B provides that in determining whether to order electronic monitoring of the person with the victim notification, the magistrate would hold a hearing and consider the likelihood that the person's participation in electronic monitoring would deter that person from injuring the protected person. The magistrate has a variety of factors there to consider, including the gravity and seriousness of the harm inflicted, the person's previous history with domestic violence, the person's history of other criminal acts, the person's access to a weapon, whether the person has threatened suicide or homicide, the person has a history of mental illness, and whether the person has a history of alcohol or substance abuse. Subsection C provides that electronic monitoring with victim notification shall be ordered only with the protected person's informed consent after that person is given the following information. The protected person's right to refuse to participate in the monitoring, the manner in which the electronic monitoring technology functions and the risks and limitations of the technology, the boundaries imposed on the person being monitored, the sanctions that the magistrate can impose for violations, the procedure that the protected person is to follow if the person being monitored violates the order, identification of support services available, identification of community services available, and the non-confidential nature of the protected person's communications with the magistrate. Subsection D provides that before ordering electronic monitoring of a person with victim notification, the magistrate shall afford the alleged victim 48 hours to provide the magistrate with a list of areas from which the victim would like the person excluded. And the magistrate shall consider that request when determining the areas that the person is required to refrain from entering. If the magistrate orders electronic monitoring of the person with victim notification, the magistrate shall specifically describe the locations that the person has been ordered to refrain from going, and that has to be communicated to them in the order. Subsection E provides that a person ordered to be placed on electronic monitoring with victim notification shall be ordered to pay the related costs and expenses. Subsection F provides that an alert from an electronic monitoring device shall be probable cause to arrest the monitored person for violation of a protective order. And subsection G provides that the courts and state and local law enforcement agencies shall share information obtained via that electronic monitoring pursuant to this section. And I can take any questions.
Thank you. Committee, any questions? I do have a question. So section 1 says that if a magistrate is required to consider ordering electronic monitoring with victim notification, the bill itself is where the requirement for the magistrate to consider ordering electronic monitoring with victim notification is created, right? Does the bill create that requirement? I think on page 4 in subsection B2 of section 2 of the bill, right? That's where the requirement comes from. It would be new law, a new requirement if the bill becomes
Madam
law.
Chair. So section 2 is the section that deals with bond conditions of bail. And so the magistrate under that section under current law has the ability to consider electronic monitoring, but the information is transmitted only to law enforcement in that situation. So this would allow for electronic monitoring where the victim would actually in real time be notified if the person got within a specific perimeter. And the guidelines for that are set out in the new section, section 1. So section 2 really just references the ability to order that, and when they do, they follow the provisions in section 1.
So thank you for that. So the new piece really of the requirement would be with victim notification.
Exactly.
Okay, and then the requirements that the magistrate would have to look at to determine whether electronic monitoring with victim notification would be appropriate are there in new section 1, which is all new law as well.
Yes.
Okay, thank you.
Not every jurisdiction currently does pretrial electronic monitoring, but some of them do.
Okay, thank you. Committee, any other questions for the reviser? Senator Reichman.
Thank you very much, Madam Chair, and I don't know for sure if you can answer this. The bill would require the monitored person pay the cost and expense, and I wonder if you have any idea how much it is, and could they send this to many different people that would want to be concerned where this person is? Thank you.
Madam Chair, so with respect to the first question, I do not know how much it is. I don't know if perhaps some of the testimony that you'll hear will talk about how much it costs, but yeah, a conferee might be better able to answer that question. With respect to the second question, there isn't a limitation in the bill for how many people it could be sent to. So for example, you know, if it's a minor child, perhaps the judge would have the information sent to the parent of the minor child, or potentially if it's a young person, it could be 2 people. There's no limitation on that in the bill.
Thank you. So there's no definition of victim?
There's no specific definition of victim, no.
Thank you. Committee, any other questions for the reviser? Not seeing any, then thank you very much. Appreciate it. Committee, we will hear from proponent John Resman. He's Kansas State Representative for the 21st District in the House. And please introduce yourself and welcome to committee.
Thank you, Madam Chair. I'm John Resman. I represent the 121st District, which is the west side of Olathe. And I'm here today in full support of the bill. The bill would allow a magistrate to order GPS electronic monitoring under certain conditions with victim notification. The victim must agree to participate in the monitoring and have the right to refuse to participate. Notification could be as simple as receiving a text that the person, their abuser, is in a near location to where they're at. The bill would allow the victim to provide a list of areas to the magistrate which the victim would like to have the person excluded from. The magistrate will specifically describe the location and order the person to refrain from. The monitoring system would have the capability to track and monitor movement of the person and immediately transmit the person's location to the victim and law enforcement. As we all know, leaving an abusive relationship does not end when the person leaves the relationship. In 2024, the Kansas Bureau of Investigation report, Domestic Violence, Stalking, and Sexual Assault in Kansas reported that there were 22,000 incidents of domestic violence, resulting in just over 10,000 arrests. In the same year, there were 20 domestic violence homicides. The top two counties were Sedgwick County with 6 and Johnson County with 5. The report continues that domestic violence occurs every 23 minutes and an arrest occurs every 46 minutes, and every 18 days and 6 hours, a domestic violence homicide occurs. In the past few years, the Kansas Coalition Against Sexual and Domestic Violence has displayed storyboards at the Capitol that tell victim stories of domestic violence and unchecked anger of the abuser that resulted in death. As many of you know, I had a career with the Johnson County Sheriff's Office, and I was in charge of 2 of those investigations that resulted of the storyboards that were presented here at the Capitol. The first one was a victim. She was a house painter, and her husband showed up at the job one day and put the victim in a headlock and fired point blank into her head. A year earlier, the victim had filed a protection from abuse order against her husband, stating that he had beat her and threatened to kill her. The second storyboard involved a young woman of 21 years of age that was found dead in her apartment on Thanksgiving Day. Her boyfriend had beat her, slit her throat, and held the apartment door closed so she could not seek help for herself or her unborn child. The victim's boyfriend had a previous history of domestic violence against women. On the first incident I talked about, that occurred in Senator Corson's district, and oddly enough, my wife graduated high school with the suspect in that case. It's kind of a strange deal. During the House committee hearing that occurred on the 27th of January, there were 3 domestic violence victims that testified, and I just wanted to read one of their statements that they made to the committee. It said, "This tool is not about punishment before conviction. It is about prevention, information, and time, giving survivors the minutes they may need to lock a door, move to a safe location, or call for help when the alleged abuser violates boundaries. These extra moments can be the difference between safety and serious harm. Passing this bill would give domestic violence victims a warning that the person, their abuser, is near to the location and give the victims the opportunity and time to further distance themselves from their abuser." While I was looking at this bill, I visited Safe Home in Johnson County. And currently, at the time, there were 90 women that were being housed at the Safe Home. And we were told that it's always at max capacity. One of their concerns is that the abuser will follow kids or their children from school back to Safe Home, which then puts everybody in Safe Home, including staff, at potential harm. So this was kind of important to them also. I do want to make one recommendation on the bill, and that would be to remove law enforcement notification so that they're not constantly being pinged that someone has entered into these protective areas. And with that, I'll stand for questions.
Thank you. And I know the House is convening in a few minutes, so we'll take any questions for the representative. Yes, Senator Shane.
Thank you, Madam Chair. Representative Resman, thank you for coming and testifying today. I just wanted to let the committee know that I testified as a proponent on this bill in the House and just missed it on the calendar and did not submit proponent testimony today. But Representative Resman brings up a lot of the very important points. There's a significant percentage of additional crime that happens in this pretrial release period where where these individuals that have been charged subsequently commit a more heinous crime during this pretrial release period. This is a very important piece of legislation. Kansas tends to be a little bit weak when it comes to our domestic violence laws. This is a really good step in the right direction. So thank you, committee.
Thank you. Senator Bowser.
Thank you, Madam Chair, and thank you, Representative. You just touched on a concern that I had, and I think maybe you suggested an amendment that we remove language that law enforcement be notified. Did I understand you correctly?
Yes.
Yeah, because I had the same concern. I thought, well, they're just going to get pinged all the time, and it's not really probably necessary.
My concern would be that, that the suspect would drive through that zone just to drive law enforcement crazy.
Yeah, so, okay, thank you for that. Sounds like we have an amendment coming. Thank you.
Thank you. And I had a question before your testimony concluded. Have other states enacted anything like this?
Yes, this is from actually 2 states, Tennessee, which enacted it, and that's where we got the idea from, and Missouri.
So those 2 states?
This bill is a combination of those 2 states.
Okay, thank you. Any other questions for Representative Restman? Yes, Senator Bowser.
Thank you, Madam Chair. Sorry, how about historical data? We're getting pings, I'm assuming, and is that, how much data is retained? Would we have a history of the suspect's movements, or if we train that data, where would that be retained at? Or can you speak a little bit to that, please?
Well,
Thank you.
all I can think of, I talked to Johnson County Department of Corrections that does electronic monitoring, and they didn't mention about keeping any records. I also talked to a bonding company that does court-ordered electronic monitoring also, and they didn't mention anything about how long they keep their records. I would imagine they would have to keep some type of record for court purposes.
Okay, thank you. I'd be just curious to know what that is. Thank you.
Thank you. Committee, any other questions? Not seeing any, then thank you very much, Representative, for your testimony today, and we'll get you to the House on time. So
Thank you.
thank you, appreciate it. Are there any other persons wishing to testify as proponent on the bill? Not seeing any, then committee, you do have proponent written testimony from Michelle McCormick, Executive Director, Kansas Coalition Against Sexual and Domestic Violence, and Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Do we have anyone wishing to testify as neutral or opponent on the bill? Not seeing any, then we will close the hearing on House Bill 2479. With that, then, we will turn our attention to opening the hearing on House Bill 2653, requiring the Secretary of Corrections to assist inmates with obtaining identification and employment-related documentation prior to release from custody. And with that, a brief from the reviser.
Thank you, Madam Chair. This bill would create a new section of law that requires the Secretary within 9 months prior to the release of an inmate from custody to determine whether the inmate has current versions of certain documentation. If the Secretary finds that the inmate does not have a certified copy of a birth certificate, a Social Security card, or replacement Social Security card, or a driver's license, or an identification card if they're otherwise not eligible to have a driver's license, the Secretary shall make a reasonable effort to provide the inmate with that documentation. If the Secretary finds that the inmate does not have their vocational training record, their work record, any educational certifications or diplomas, or a current resume, the Secretary shall provide the inmate with that documentation. The Secretary shall coordinate with state agencies as necessary to gather the documentation, and all state agencies shall coordinate with the Secretary to implement the provisions of this section. The new section does not apply to inmates who are going to be released from custody to another jurisdiction on a warrant or detainer, or to inmates who are determined by the Secretary to be physically or mentally unable to return to the workforce when released. And I can take any questions.
Thank you. Committee, any questions for the reviser? None. Okay, great. Well, thank you very much. Appreciate it. First, we will hear from proponent Dr. Chris Fanning, Executive Director of Programs and Risk Reduction with the Kansas Department of Corrections. Please introduce yourself and welcome to committee.
Thank you, Chairwoman Warren. I apologize, I've got a little sore throat happening. Chairwoman Warren and members of the committee. I'm Dr. Chris Fanning. I serve as the Executive Director of Programs and Risk Reduction for the Kansas Department of Corrections. Thank you for the opportunity to provide testimony in support of House Bill 2653. I appreciate the committee's continued consideration of this policy, which has previously received bipartisan support in the House of Representatives. The Kansas Department of Corrections strongly supports this bill because it represents a practical, data-driven step toward improving public safety through successful reentry. House Bill 2653 focuses on a simple but critical goal: ensuring that individuals releasing from KDOC custody leave with the identification and employment documentation necessary to transition successfully into the workforce and community. Specifically, the bill directs the Secretary of Corrections to assist residents in obtaining vital records such as birth certificates, Social Security cards, and driver's license or identification cards when eligible, while also ensuring individuals receive copies of vocational records, work history, educational credentials, and a resume prior to release. For most Kansans, these documents are routine. For justice-involved individuals, however, the absence of identification can create immediate barriers to employment, housing, healthcare access, and supervision compliance. Nearly all residents will eventually return to our communities, and their ability to secure legitimate employment quickly is one of the strongest predictors of reduced recidivism. This bill supports that outcome by removing administrative obstacles that currently delay workforce entry. Importantly, House Bill 2653 builds upon work already underway within the KDOC. Release planning begins well before discharge and includes coordination with case management staff, workforce partners, and external agencies. The bill strengthens those existing practices by establishing a clear statutory framework for interagency collaboration and by ensuring consistency across facilities. It does not create new programs. Rather, it formalizes and scales strategies that have already demonstrated success, including driver's license and identification clinics that help residents leave custody better prepared. This legislation benefits more than the individual leaving incarceration. Employers gain access to a broader workforce, communities experience safer reintegration outcomes, and the state reduces long-term costs associated with unemployment and recidivism. By focusing on preparation rather than reaction, House Bill 2653 aligns with Kansas's broader goals of strengthening public safety while promoting accountability and self-sufficiency. For these reasons, the Kansas Department of Corrections respectfully asks the committee to support House Bill 2653 and continue advancing policies that remove barriers to employment and reinforce successful reentry. Thank you for your time and consideration, and I'm happy to stand for questions.
Thank you, and we'll go ahead and reserve any questions till after we've heard from all the proponents.
Thank
Next,
you.
we will hear from proponent Logan DeMond, Director of Policy and Research, ACLU, Kansas. Please introduce yourself and welcome to committee.
Good morning, and thank you, Madam Chair and members of the committee. My name is Logan DeMond. I'm the Director of Policy and Research at the American Civil Liberties Union of Kansas. We're a nonprofit, nonpartisan organization that works to protect and strengthen the civil rights and liberties of all Kansans. We're here this morning because we're in strong support of House Bill 2653. And I'd like to begin by simply saying that this is the kind of evidence-based reform, evidence-based assistance we support, and we are happy to already be seeing at the Kansas Department of Corrections. In our written testimony, I pointed out the various obstacles to finding employment, housing, healthcare without valid forms of identification or other necessary documents. We've already heard that from another proponent this morning. What this bill does is say that the KDOC today, tomorrow, and years down the road under any given secretary must provide this assistance to the 95% of incarcerated individuals in Kansas who will one day return to their communities. Just to zoom in on that figure a little bit more, 33% of those incarcerated individuals will serve less than a year, 47% will serve less than 2 years, and 66% will serve less than 5 years. In addition to supporting best practices for reentry and joining 6 other states in codifying these practices, this bill will reduce recidivism and increase public safety. On behalf of the ACLU of Kansas, I strongly encourage you to support House Bill 2653 and bring us one step closer to getting this bill across the finish line in its original form. Thank you, Madam Chair, and I'll stand for questions at the appropriate time.
Thank you, appreciate it. Next, we will hear from Chris Stanier, Chief Mission Officer, Goodwill Industries of Kansas. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. My name is Chris Stanier, Chief Mission Officer with Goodwill Industries of Kansas. Our mission is to transform lives and communities through the power of education, training, and employment. I will say that we are standing in proponent of this bill, 2653. We have found that the impact on individuals is immense, as Dr. Fanning had alluded to in earlier testimony. When individuals are released from incarceration, the clock is ticking. There are a number of obligations individuals need to keep to be able to maintain their freedom as they're going through the reentry transition process. There are a number of barriers that prevent individuals from meeting all the obligations that they have. We, in fact, witnessed this firsthand as members of our leadership team actually went to a reentry simulation event. And this event gave us the materials that we were going to need, a small handful of resources and a list of all the obligations that we had to meet. We think we're fairly intelligent people and fairly resourceful people, yet it wasn't 10 minutes until a member of our team was in the simulated jail for not being able to keep up with the obligations and demands that were put forth before us. It is a very difficult road to travel, and not having the proper identification creates a significant barrier to not only receiving resources, but accessing transportation, accessing employment, and all the other individual resources that you've heard of here today. There are right now 28 other states that have this legislation, and I'm excited to see that Kansas is considering adding themselves to those ranks. It's important for us to be able to move forward and make a difference in these individuals' lives, and for the state to be able to work with us in such a way that removes a barrier such as this is very important to what we are trying to do. It's important to the individuals that are working to change their lives and individuals who will ultimately rejoin our workforce in in-demand occupations that will strengthen us as a state. So I stand again in favor of this bill and would also direct you to written testimony that was provided to a partner agency of ours. Goodwill is made up of a number of agencies, 141. And so we have our testimony that you've heard here today, and we also have testimony from the MERS Goodwill, which is Eastern Kansas and Missouri. So with that, I'll be happy to stand for questions at the appropriate time.
Thank you, appreciate it. Is there anyone else wishing to testify as proponent on the bill? Not seeing any, then we will go ahead and open it up for any questions. Senator Haley.
Madam Chair, thank you, and I thank the proponents. Well, first, thank you, Madam Chair, for bringing this bill up, 2653. As you know, it passed the House unanimously, or I just looked it up and it did. I just wanted to say to the proponents and to the committee that I'm strongly supportive of it. I think we all did. I didn't know some of these tenets were not in place already. Recidivism continues to be a tremendous problem within our jail, our rate that we have, and this will address it. So to the proponents, I appreciate them bringing this and this discussion we're having. I've sat for many years on the Kansas Sentencing Commission, and to identify those that are going to be released and to have this put in place, their employment and to have identification and employment opportunities are essential. That's my commentary, but Madam Chair, my question is the others, and I think one of the conferees was mentioning it of the proponent. The other component is homelessness or housing. So as we look toward identification and geez, I thought we were doing some of this already. We should have been a long time ago. But is there a component piece for some of the other states is my question regarding ensuring that housing, a seamless transition for some firm housing is in place. So beyond identification, beyond employment opportunities, that there might be firm housing. Has any of the proponents considered that, since that too leads to a large amount of recidivism?
Thank you. Do we have a proponent who wishes to reply? Please go ahead and reintroduce yourself. Thank you.
Thank you, Madam Chair and Senator. I am Dr. Chris Fanning. I'm the Executive Director of Programs and Risk Reduction for the Kansas Department of Corrections. In response to your question about housing, yes, absolutely. Housing is one of the key elements that we look at when we begin our release planning, 16 months from release. We do start looking at it before that, but formally we start looking at it 16 months from release. We explore various options. We put primary residency, secondary residency. We list all those options and we work with the individual to identify that. Not everybody has adequate housing once they release. As the KDOC, we do have a few housing contracts within our department where we do try to place people and help them transition into more permanent housing.
Well, thank you, Dr. Fanning. Madam Chair, are there existing organizations now that are around the state that the department might work with that are providing some of these services, those not only contained in the bill, but housing and others already that the department interfaces with, that the Department of Corrections interfaces with or works with to meet these objectives that you're aware of?
Yeah, Madam Chair, Senator, thank you for that question. We have begun engaging in various conversations. I believe one of the most recent has been with the Topeka Housing Authority, and we've been engaged with them in conversations about how they could potentially partner with us to find solutions to these issues. We're also part of some larger groups around the state. I'm privileged to be part of what's called a Returning Citizens Consortium with Mr. Stanier of Goodwill and several other organizations around the state where we are actively seeking partnerships in order to address issues such as housing, transportation, and those other barriers that we can maybe help remove for individuals who are returning to our communities.
Thank you, Madam Chair. Thank you, Dr. Fanning.
Do you have a follow-up or?
No,
Okay.
no, I appreciate that. Thank you for the responses.
Great, thank you. And
Thank you,
while
Madam
you're
Chair.
at the podium, I wanted to share that I'm glad to hear the explanation from the Department of Corrections that though they already engaged in this process, that the law, I'm like, well, why do we need a bill then? Why do we need a law? And I had heard the department say for consistency purposes, for the interagency cooperation to help get some of these documents in place, and then of course for the safer reintegration and strengthen public safety as well. So I was glad to hear that explanation in your testimony.
Thank you, Madam Chair.
Thank you, appreciate that. Senator Bowser.
Yeah, thank you, Madam Chair. And I just add on to the senator from Wyandott's remarks. I kind of thought we were already doing this. I was surprised we weren't. And then I thought, well, maybe the reason we're not is there's some big fiscal impact. And I just note for the committee's sake that Department of Revenue and Department of Corrections indicate no fiscal impact. So I'll be a big supporter of SB 2653. Thank you, Madam Chair.
Thank you. And just for clarification, the Department of Corrections is already engaged in this practice, but it's needed to strengthen the practice and to make it run more efficiently and more cooperation with other agencies in the state. Is that right?
Madam Chair, members of the committee, yes, that is correct. We've been engaged in internal driver's license clinics for the past 4 or 5 years. I'd have to look at my data. And each year we've been increasing the number of individuals who are able to obtain their Kansas driver's license or state identification before they return to the community. We're also actively engaged in, of course, helping people access that replacement Social Security card as well as their birth certificate, even if they were born out of state. So we have been actively engaged. To your point, this is definitely legislation that will help provide consistency across facilities, but also weather through administrative changes to make sure that it is common practice down the road.
Thank you. Committee, any other questions? Not seeing any. I did want to ask, probably for Chris Stanier, is this kind of do we see a lot of this in the metropolitan areas? I do see we have Goodwill Industries of Kansas and then Missouri Goodwill Industries as a written proponent that is for communities more urban, less urban, or kind of, I would think, would impact everyone.
Yeah, no, that's a great question, Madam Speaker. Thank you. We see a larger proportion of services needing to be provided in the urban areas. Typically, individuals who aren't released from incarceration in more rural areas have a strong likelihood of actually locating back to a higher urban area like Wichita or Kansas City, even Topeka, primarily due to the resources that are available.
Thank you. Appreciate it. Then if there's no one else wishing to testify as proponent, I want to direct your attention to proponent written-only testimony from Kristen Wood, Director of Development and Advocacy, MERS, Missouri Goodwill Industries, and Brenna Vyskowski, Campaign Director, Kansas Appleseed. Is there anyone wishing to testify as neutral or opponent on the bill? Not seeing any, then we will go ahead and close the hearing on House Bill 2653 and thank everyone for their participation. And we do have folks in the gallery today that I wanted to have our committee be introduced to, and if we could have a brief introduction to those folks at the request of the Kansas Bar Association. And one of them includes one of our revisers who you have not seen sitting at the staff table today, but she's part of the group that's in the gallery this morning.
Madam Chair, Joe Molina with the Kansas Bar Association. I appreciate the shout out. Today we have the KBA Leadership Institute group. There's 12 young lawyers new to the profession who have joined us, and we're taking them through 3 or 4 days throughout the year. And today is meeting with you and seeing how the legislation that they practice in the law has worked. We have our Executive Director, Sabrina Thompson, here with us from Kansas City Mo. We also have Daniel Atchison, who is the chair. If I could have them stand real quick.
Sure, that'd be great.
Stand up, guys, everybody. I appreciate you giving us this opportunity. We'll be around the Capitol for a bit. We actually have a CLE here later on this afternoon. So thank you very much, and I appreciate the time.
Great, thank you. Well, thank you all for being here. Appreciate it. And good luck in your studies and your endeavors. I think the program's pretty new, I'm not sure, but I will learn more when we have an opportunity to visit. So thanks very much for visiting the Capitol today. With that then, committee, that concludes our business for today, and we will, the meeting is adjourned.